Head to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides, fun, and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to
Hey, everyone, welcome back to the day that never ends. Sleep is for the weak. Breaks are for the... I don't know. We keep trucking. Hoot, hoot. You really rate because I paid for Wi-Fi from... Oh, thank you, Crispy. Then I have to come here and give you some entertainment. Well, I can't give you it with this trial because today they are back to their normal. We are not doing anything really other than get objected against all the time. I know there's a case in Colorado. It's a woman who allegedly stabulated her husband, boyfriend, put the house on fire. I have suggested Mo to do it. Mountain time is a little rough to do for me because that'll be 4 p.m. is 12 o'clock for me. So, and I have 3 days of care and read next week. I have this one running. I'm working on something for the weekend as well. So I have way too much on the menu right now. So I hope Mo is picking it up. She has been having that horrible bass case. So I suggested that she should take that case because I think it's an interesting case, but I just can't. Mountain time is really hard to fit in with my normal schedule. And I have so much on my plate. That's the word I was looking for before. So I hope Mo is going to do it. I'm going to black out doing this as an FUI. Well, get those Goldslagers in you. Yeah. Let's see if it gets better. Morning was, like I said, yesterday I was about to drop it. Then it became really good. And today it's back to being crap. But we have a lot of things going next week with the Care and Read. There's potential 3 days of Care and Read next week. My wonderful mod team and I, my head of booking and yelling, is trying to set up something over the weekend. Won't be any stab your day. I have a nephew who turns 10 Saturday, so there won't be anything Saturday. I don't know. Maybe I'll do something when I get home, but Sunday I'm looking into doing something. So keep an eye out, because Sundays are always dead on YouTube. So we are moving some pieces around and seeing if we can't do something interesting for you on Sunday. Sunday. And let's just get back to this and see if they can figure out what, if any, is a flip phone. And thank you so much to Julia for jumping on and interesting me in the Coburger case. It's there's a lot of weird cases going on. Apparently, I'm always grumpy, according to a certain rebel scum supporter.
You're fine. Okay, we'll go back on the record. Mr. Castle, you can return to the stand. I would just remind you that you remain under oath. Sorry.
Your Honor, I just ignored the scheduling thing.
Okay.
I just mentioned this to Mr. Mullis's attorneys, but my understanding is there are 2 witnesses who have arrived in the courthouse who are here under subpoena, both from the Des Moines area. I just want to make sure that we accommodate them if possible.
Okay. I guess, counsel, what are your thoughts about then how we spend our afternoon?
We feel the same, Your Honor. Our goal is to finish this witness expeditiously and move on.
All right, we'll plan on that. Ms. Steenson, you may pick up with your questions whenever you're ready.
Thank you, Your Honor. Mr. Castle, we were talking before break about the creation of Amy Lynn 58.
Someone support overturning democracy and rebel scum from my mud base. I have had complaints about her before, and I still, because I believe in the freedom of religion, and she's a member of a weird religion, thinking that lightsabers and dancing rocks is something. But I allow it. I'll allow it.
10 Google account. This was the Amy Mullis Google account that was only on her phone and not on the family iPad?
That is correct.
And from your testimony earlier this morning, this was the later created of the 2 Google accounts that you associated with Mrs. Mullis?
Her device, yes.
Do you know when that Amy Lynn 5810 Google account was created?
Without referencing the exhibit that contained that artifact, I don't recall off the top of my head.
Would looking at the metadata TXT file from the extraction of Amy Mullis's cell phone refresh your memory
Yes.
about? Okay, yeah, can you just show that? Yeah, I'll show it. I'll show counsel what we are putting on. I would like you to just read this to yourself.
Thank you.
Okay, you can remove it. Did that refresh your memory about the creation of Amy Mullis's Gmail account?
Yes.
And what was the date of that?
July of 2018.
And what was the, do you have the exact date?
19th.
Thank you. So July 19th of 2018?
That's correct.
Did you review or extract data from a phone connected to Mrs. Mullis's phone with the last 4 digits 5678?
Yes.
And 5675, I apologize. I misstated that. The last 4 digits 5675?
I believe that was the number associated with that other device, yes.
And do you recall when this data, the data on the phone started?
I don't.
Would it refresh your memory to look at a copy of the extraction
Yes.
data? Just one moment. I will have to bring this up to him. So,
Okay.
did that refresh your memory?
Yes.
Mr. Castle, when was the first earliest call on this phone?
July.
what was the date?
I believe it was the 14th, if I remember looking at that. Was it July 14th, 2018?
Can I
Sorry.
approach the witness again to refresh?
Certainly.
You just looked at it. Hey, leader.
I apologize. It was July 22nd.
Does that mean that there was no data on her phone prior to that date in 2018?
No, there was data on the phone.
But no, what data would be available on the phone then?
The artifacts represent the activation of the device and the new call log beginning.
So the call from, what data then was missing before July 22nd, 2018?
Sorry, I'm having a hard time following your question. You're asking me, first of all, when this number started being used, as it was tied to which device specifically?
The cell phone that you extracted.
Okay.
No, that's not her question. She asked what data wasn't there before July 22. How would he know?
And the
Let me re-ask the question. Based on the cell phone that you extracted for Amy Mullis, and your testimony today was that the earliest call on the phone was from July 22nd, what does this indicate to you?
the possibility of a factory reset.
Did you receive and review Google search history from a subpoena to Google showing Google searches associated with the Mullis RN Google account?
I did.
And did any of those searches search for the term related to the recovery of a phone?
It did.
And what does it mean to recover a phone?
The end user chooses to possibly reset the phone back to its default configuration due to troubleshooting steps or obfuscation of data contained on the device.
Is that sometimes? Can you tell me what you mean by that?
So troubleshooting, meaning that the end user was possibly experiencing some problems or issues with the device, and at the instruction of the carrier, they may have reset the device to solve those problems because a factory reset will put the software in a default configuration, which will eliminate a lot of problems. Or secondly, the obfuscation of data, meaning that they reset their phone to hide something.
The search you saw from the Mullis RN Google account relating to the recovery of an LG phone, do you remember when that search was from?
I believe it was in the July timeframe.
Do you know the specific date?
I thought it was around a couple days previous to the reset.
Would it refresh your memory to review the metadata files from the search of the extraction data of the Mullis RN account?
Yes.
Okay, I will show opposing counsel. May I approach?
May.
If you could review this for me, Mr. Counsel, starting right there.
So the signature here, the enter right above it.
I
So,
had
just
LG
review it.
2, 3, 4, 5.
Do you have an
I love
independent
those
recollection
ones.
based on your review of that?
Yes, there was a search on the 20th of July, and then again earlier that day on the 22nd.
I would like to publish what has been previously admitted as Exhibit 374, page 55, which is Amy Mullis's U.S. Cellular phone records. Do you see this?
Yes, I can see the phone records.
Approximately what dates does this specific page cover?
From the 19th through the 26th of July,
In what year?
2018.
And this is, just for clarity of the record, this is page 55. Does,
Sorry, page 55 of the exhibit.
well, I'll just represent to the court that this is page 55 of the document of Exhibit 374. Does this phone record on this page show SMS activities associated with Ms. Mullis's phone?
Yes, it shows both SMS and MMS messages.
And can you tell me what that means?
SMS is signal messaging service for plain text messages received or sent from the device, and MMS is multimedia messages sent or received from the device.
Looking at this particular page, there is an SMS number that is shorter in length. Can you tell me the date and time of that entry?
Yes, it's 3:04 p.m. on 7/22/2018.
And can you tell me what a short SMS code is?
It's typically used by carriers or subscribers to do a couple of things. One, either an advertising blast that would be received via SMS, or possibly a two-factor authentication code sent to a device for authentication purposes.
So this potential reauthentication or of a Google account was at the same day as a search on the Google the Mullis RN Google account about recovering a phone?
Yes.
Did you review Mr. Castle, do you have experience with obtaining and interpreting cell tower location data?
I do.
Can you tell me a little bit about that experience?
Yes. In multiple cases that I have either offered affidavit or testified in, I have received subscriber intelligence data as pertains to call data records, per call measurement data, and other similar type signals information that allows me to triangulate and locate the handset of a given subscriber.
Can you explain in general terms what cell tower location data is?
Yes. There are several spreadsheets that are created as a result of the subpoena to the carrier of Verizon or AT&T that are given to the government in response. That data contains multiple items that are used to build triangulation and mapping of the handset. Those are the geolocations of the cell towers themselves and the pointed direction of the antenna on that cell tower. They are in a 120-degree grids, which would make a 360-degree grid array combined. And then with the call data records, as applied to the communications coming off the device, whether they be SMS calls or MMS, those signals are used to triangulate the location.
Yeah, but would you use an inexperienced lawyer for this very technical data that is kind of one of the linchpins in this case? You can let this inexperienced lawyer talk to the farmer we saw yesterday. It's really annoying that the lady next to her is constantly
of the handset in relation to the cell tower at the time of that communication. That's as it pertains to call data records. Now, per-call measurement data, which is a specific carrier term, is a measurement that is taken. Radio frequency travels at the speed of light, which is a determinate variable, and can be used to triangulate handsets. It is a more accurate measure of where a handset may be than call data records, as it is a radio frequency transmission communication between the handset and the tower itself. This information is more accurate simply because that measurement is taken periodically as the handset moves. As a general rule, mobile cellular handsets do not necessarily talk to the tower that is closest to it. It talks to the tower that has the best signal strength. So that has to be determined. That's determined by this measurement of the radio frequency and its signal strength in relation to the handset and the tower itself.
So just to put it in a little more simpler terms, can the cell tower location data help an expert determine the location a cell phone was at the time it was in use?
No. Yes.
Did you review phone records of Jerry Frazier?
I did.
And where did you get this information?
I received it as part of the data I got from the government.
And what did you receive originally?
Originally, I received only a few pages or excerpts from these documents that would typically be turned over by the carrier.
I would like to show what has been previously marked as Exhibit 298. Mr. Castle, what is this?
This is a part of those batch of documents that I referred to that will be received from the carrier. This specifically talks about the geolocation of the cell tower and the direction that the gridded array would be facing.
Array?
Correct.
And this was provided to you originally in 2022?
Yes.
You can take that down. I would like to show what has been previously marked as Exhibit 299. Can you tell me what this is?
Again, this is an excerpt of what would have been a total data dump from the carrier containing data as it pertains to, as I stated earlier, the call data records of the CDR and the SMS communications coming off of a handset.
And this also was this was originally provided to you in 2022?
Yes.
Based on your analysis done with these two documents that I just showed you, what did you find?
My conclusions were incomplete because these documents are incomplete. I did not have all of the data necessary to do a proper triangulation or mapping of the handset in question.
Was there any data on November 10th of 2018?
No.
Did you ever review any other documents regarding Jerry Frazier?
At a later date, I was ultimately provided with all of the call data records and necessary information to build a more comprehensive mapping of the data, but this was after I had authored my original report.
Especially because the defense doesn't seem like they're prepared to ask questions about it. They are all over the place and they're not getting anywhere. And the judge was really mad this morning about it. And yes, this is at 1.5 speed.
Would these documents, these that you were presented later, potentially change your opinion about whether it was possible to determine the location of Jerry Frazier's cell phone on November 10th, 2018?
If the data was not reflected for that date in particular, no, it would not aided me in producing a location of the handset for that particular day. It did aid me in understanding where the handset may have been on all days previous to that.
I would like to publish what has been already admitted as Exhibit 271, page 11. Can you highlight it to me just like? Here
Why
are
does
the dates
Brandon and
of
Jimmy make me watch this
July
class?
2nd, 2018. What is primarily being searched here?
The subject matter surrounding Ohana tattoos.
And were you aware of any communication regarding Ohana tattoos in the digital evidence that you reviewed?
Yes, there was a conversation in the communications between Ms. Mullis and another party surrounding her getting one of these Ohana tattoos.
I would like to publish what has been previously admitted as Exhibit 262.
It's absolutely annoying. What's an Ohana tattoo?
And looking at the top of, can you tell us what this document is, purports to be?
It appears to be the communications between Ms. Mullis and another party.
And at the, and can we scroll to page 7?
Oh, I hate those tattoos.
Can you tell us what the date of this text message is?
This document would seem to reflect that the communications happened on July 2nd. It doesn't state a year in the pound date stamp.
You can take it down. I would like to show the witness what has already been admitted as Exhibit 271 on page 57.
So like my stick figures of my girls.
Mr. Castle, you previously mentioned that you knew the iPad was activated on August of 2017. Why was this significant in your analysis?
It appeared that there were Google searches that were conducted previous to its activation.
And in looking at Exhibit 271 on page 57, can you tell us the date of the first search?
The first search that Google has record of for this account happened in March of 2017.
Mr. Castle, did you review the Galaxy DVR security cameras from the Mullis family farm?
I did.
And did you perform?
It's the Marines that says no body left behind. It's not Lilo and Stitch. Lilo and Stitch is a cartoon. Really need to grow up and smell the coffees. This may be a dumb question. Do they have to use the lawyer who is asking the questions? Otherwise, I don't know why they are. Maybe it's to get her some training, but I would have done that with the friendly farmer yesterday. I would give her a softball witness, not very technical stuff that she clearly doesn't understand, and she has that going in her ear the entire time. I would hate doing that. That's why I hate whenever Jamie is in private chat just talking despairingly about me, because it hurts my fifis.
Data extraction on the security camera system?
I conducted my own independent collection or extraction of the data, and then I also conducted an analysis of the data contained within that hard drive image.
Can you tell me what your analysis and conclusions were?
After the proper procedures followed for the collection of that device, I took the opportunity to extract specifically the system's log file of that DVR, which reflected the community.
Everyone still have eardrums, but you can hear that mic. You can hear the tapping louder than anything else. I don't know where the mic is placed, but someone has a mic placed on the court reporter's keyboard.
Communications of the cameras with the DVR unit itself. The cameras were a wireless connection to the DVR and reflected a number of disconnections over a period of time.
I want to break this down just a little bit. Did the system record any footage from October 29th, 2018 to November 11th, 2018?
I did not appear to have made a record of any recordings for that time period.
Could you determine whether any video footage was deleted during that time frame?
Yes, I was able to determine by doing analysis on the file system that there were no video files written for that time period, so there would not been any files deleted for that time period.
And can you remind me what program you used for this extraction and analysis?
I used FTK Imager to create the hard drive image, and I used DME's EVR Forensics, the same title the government used.
So this was the same program that was used by the state?
Yes.
Was there any activity on the camera at all between October 29th, 2018 and November 11th, 2018?
The log files reflect that there were a disconnect of the cameras from the unit itself.
Why would a security system stop recording?
Objection calls for speculation and foundation.
Overruled.
The log files represent a connect and disconnect of the cameras, which again were a wireless connection to the base unit. And this connection and disconnection of the cameras to the base unit would be an explanation as to why there was no footage recorded at the time.
Did you learn through your review of the materials where the camera DVR system was located?
I learned from the materials, and also in September of 2022, when I visited the Mullis family farm to retrieve a number of these devices I had opportunity to extraction on, I did a site survey to determine what building and office the base DVR unit was located in relation to the cameras that were on the hog barns independently.
And what was significant about having this knowledge?
It gave me a physical awareness of where the cameras were at in relation to the base unit itself.
So how did this impact your analysis and conclusions?
It was a further correlation that demonstrated the accuracy of the log files and their reflection that the cameras had disconnected from the base unit.
Did you review Mr. Hemesat's testimony regarding the camera's system footage?
I did.
Did he testify that he could not tell whether the camera did or did not record?
Objection transfer to
Overruled.
Yes, I do recall that. He may have not had opportunity to look at the log files that I did.
Was his statements true?
Objection, this is improper opinion testimony.
Overruled.
It would appear that they did not have all the data necessary to make that conclusion.
Is your conclusion based on the data that you extracted?
It is.
And this is also the same data extracted by the state?
They had access to the data. I don't know whether or not they extracted or did analysis on that data.
But they had access to the system log to come to the conclusion that there was no data on the phones, on the cameras between October 29th and November 11th?
Correction leading.
Overruled. The answer will remain in the record.
Can I have a moment?
You may.
If you were called to testify at Mr. Mullis' trial in 2019, could you have offered this opinion, all these opinions?
I've been retained by counsel.
She is, she's getting really annoyed. You can hear it in her. She's starting to do the Bev sigh.
For the purposes of analysis in these matters, my findings would be as they are.
Thank you. No further questions at this time.
Cross-examination.
Thank you, Your Honor. I'm going to pick up where we left off. Your testimony was that your findings would be as they are, right?
With the exception of the satellite, with the exception of the call data records and the mapping of the handset, yes.
So that means you used the existing software versions that were available at the time of the trial in 2018, and you didn't use any new versions of software, is that right?
I did have a couple newer versions of software, but it did not reveal any additional data that I used as part of my findings.
So let's break that down a little bit. So you stated that you used several different types of software. So, for example, you used Celebrite, I believe Magnet Axios, and FTK, among others. So we'll use Celebrite as an example. Celebrite comes out with new versions of software as time goes on, right?
Often on a quarterly basis, yes.
And
on a quarterly basis, oftentimes, yes.
Thank you for clarifying that.
Delta, not SEALs.
So in those software updates, Celebrite would change how it extracts information from devices, right?
Sometimes, yes.
So, for example, it might change what encryptions it can break or new versions of iOS or Android that it can extract data from?
Yes.
Because you have to prove that they need to give him a new trial. And yesterday they had a good witness. Today, this witness, it's been like driving with Jamie, going fast nowhere.
And that would be the same for the other types of softwares that you used?
There are often enhancements contained within updates, yes.
And as part of those updates, they're able to extract more information as, for example, Android software gets older, they can find new exploits.
It's getting worse, brother. Just let it go. Let it go, let it go. It can't hang on anymore. Let it go, you are bald. And it's just so easy to see. So take those shears and take it off. Your hair's not gonna cover it anymore.
Extract more information as, for example, Android software gets older, they can find new exploits to look at that information, right?
Yes, that is true.
And if you use a newer version of Celebrite software, just as an example, you might get new or different information than what was available in 2018 based on old versions of Celebrite. Isn't that fair?
Hey, that is fair.
I guess continuing to work our way backwards through your testimony, you finished, towards the end, you finished off by talking about the Galaxy security camera system. So essentially, you're relying on the logs to indicate that the cameras were never connected. Is that your testimony?
The cameras are disconnected for a period of time over the life of that DVR, and specifically in the time frame I was questioned about.
And you don't know why they weren't connected, right?
The log file represents that the wireless connection, as established between the main unit and the cameras, represented a disconnect.
So you don't know what caused that disconnect beyond that? Is that fair?
Until the physical inspection of the site, that would be correct.
So for example, if the, I guess I'll just say this, you don't know specifically what caused any disruption or disconnection of the cameras.
That's fair.
Thank you. In your report, you discuss the Galaxy camera software and the extraction done by the law enforcement officers. Is that right?
Yes.
And turning to that section of your report, and do you have this report in front of you?
I do not. I don't know that it was admitted.
Just to move this along, I'll read from it and just make sure that we're on the same page. So on page 11 of your report, you state, and just tell me if this sounds wrong at the end here, according to a DCI examination synopsis report, Deputy Hemiseth attempted to access the security camera system without the proper software or extraction tools. Does that sound familiar from your report?
It does.
Do you now know that testimony or that portion of your report to be false?
Objection.
I asked if he knows.
What's the objection?
It assumes what it is saying.
Overruled. You may answer if you can.
I'm unaware from trial transcripts or the report from DCI that former Deputy Hemiseth had opportunity to review the log files as reported that I did.
In preparation for your testimony today, I believe you indicated that you reviewed Ward Crowley's report and his testimony. Is that true?
In part, yes.
In what part is it untrue?
I recall reading it. I don't recall the totality of it at the moment.
Were you aware that Ward Crowley specifically testified, which is in evidence here, that this is not what occurred?
In what aspect?
Were you aware that it was DCI Special Agent Ward Crowley who conducted this attempt of the extraction of the security camera system at the Sheriff's Office and not Sheriff, then Deputy Hemiseth?
I do recall that aspect, yes.
Okay, and then your report continues on to say that I'll just read it since you don't have it in front of you. You say, DCI Agent Ward Crowley attempted to assist Deputy Hemiseth remotely while Hemiseth tried to conduct an on-site examination of this device at the Sheriff's Office. Does that sound familiar?
Yes, it does.
And you now know that that's not true based on the testimony and evidence here, right?
Hey, I'm sorry, which aspect of the testimony?
Well, you say in your report that Ward Crowley assisted remotely, but he testified in this proceeding that he was there in person, right?
Okay. That part of the testimony I must have overlooked. I apologize.
I'm sorry, you just testified that you reviewed his testimony, right?
In part, in that I don't recall every aspect of his testimony.
That misstates his testimony. You're referencing a report here, and testimony is different than a report.
Yes, you've admitted the report and evidence.
That's not necessarily what he's reviewed. And that's not his testimony today, that he's reviewed the report.
Your Honor, I think I can clear this up briefly. I'm referencing the deposition of Ward Crowley, which is admitted into evidence here. Ward Crowley specifically explained how this extraction occurred. If they want to point me to something that contradicts that, I would be happy to revise my question.
Okay, and again, I think her point was that this witness maybe wasn't present at that deposition or wouldn't have that clarification necessarily. Let's just have a new question, please.
Thank you, Your Honor. If I understood your testimony earlier, and I just want to get clarity on this, your testimony on direct examination was that you reviewed the report and testimony, which would only be the deposition from this PCR of Ward Crowley. Is that correct?
An opportunity to read that deposition. I do not recall the part where he was on site to do the analysis of the log files that were extracted specifically. My report in spirit reflects the fact that the log files about the connections between the main unit and the cameras were disconnected.
And maybe I can help clarify here. Do you recall any testimony from Ward Crowley in your review where he discussed attaching the physical right blocker device to the system?
I do recall that.
Okay, so would you agree that if he was attaching a physical device to the system, he would have to be there in person?
That would make logical sense, yes.
And there was some discussion in his testimony, without getting too granular, where he referenced using a trial version of the software. Do you recall that?
I do. I also recall during the course of that interaction that there was a phone call between the two of them regarding his analysis as well, and that may be what I was referencing when I was talking to the remote assistants.
Thank you for clarifying that. So you completed a report in this case, right? This is the general report of your findings that we've been discussing?
Yes.
Have you completed a supplemental or updated report correcting any of these discrepancies since this report?
No, I've not been asked to do so.
I briefly want to talk about your background. At the beginning of your testimony, you talked about your background into digital forensics and network security consultant. Is that right?
Yes.
And you referenced dealerships as part of your background. That specifically is car dealerships, right?
Yes, in the automotive industry.
Okay, so your CV, where it indicates that you work for example, Sid Dillon, Chevrolet, Buick, GMC, Cadillac, Mazda, Nissan, Hyundai. That's the example of your background working at dealerships?
That's one of them, yes.
Okay, and then you work for other car dealerships?
Yes.
You don't dispute that the Google searches that all of the Todd Mullis Gmail searches that were in evidence had to have come from some device connected to a Todd Mullis Gmail account, right?
I can rephrase.
Yes, it's poorly phrased, I'll admit that. Just for clarity, we have the Google subpoena results, right?
Correct.
You're not disputing that all of those searches came from something connected to that account, right?
Correct.
And you have no way to know who specifically is on the other side of those Google searches?
Yes, that would be correct. Attribution in its truest form and understanding the patterns of usage and searches conducted. Unless there was someone that could visually witness the searches being enacted, it would be difficult to tell who was responsible for them.
Fair enough. You had some testimony about the correct meaning of UTC time, right?
Yes.
And although you referenced Deputy Hemeset getting that wrong in his testimony, you also had difficulty converting UTC time today, right?
I did.
Just so we're clear on the issue of the dish DVR, you can't specifically say what show is watched on what day in this case, right?
By the correlation of the TV guide and the unit itself, it's still some difficulty of producing the exact date in which some of those videos were watched. You are correct.
And would it be fair to say that shows can be re-aired?
Absolutely.
You had a reference to, or I'm sorry, one follow-up on that. You also don't know who was watching the show that would be on, right?
Correct.
Thank you. If you can just clarify something for me, you referenced based on user synchronization options, the searches can show up on other devices. Can you just explain what that meant?
Yes. When you sign into, as an example, the Google Chromium or Google Chrome web browser with a Google account, you are presented with options. Those options would be to synchronize those searches and history on that account with that browser. So there is a way to opt in or opt out of that synchronization happening across those multiple platforms and devices and browsers.
And are you aware if the user synchronization options were enabled or disabled on the various devices here?
No.
You testified on direct examination that the correlation of Google searches seems pretty straightforward and obvious, or something to that effect. Does that sound right?
The correlation of the Google searches to other data points available to me as part of the investigation does outline a pattern.
So if it's straightforward and obvious, we wouldn't necessarily need an expert to tell us that part?
I would agree with that.
You spoke about Ms. Mullis's phone possibly being reset, but you don't have any firsthand knowledge of why the phone was reset, right? In other words, you weren't personally there to know why?
Correct.
And because I believe you testified that it could have been for a variety of different reasons, right?
Correct.
So you can't say definitively why it was reset without speculating, fair?
The analysis of the web history and searches happening up until the point of that reset would offer some insights into the possibilities.
You also testified about your experience working with cell phone records, extractions, location data, that type of thing, right?
Yes, I did.
And you described for us what SMS and MMS messaging is?
Yes.
Would it be correct in saying that SMS actually means short message service?
It's another acronym that's synonymous with the messaging style, yes.
Looking at the VOLTE records for Mr. Thrasher, would it be fair to say that there would be a tower code in the column of those documents?
Without looking at it again, I'd have to refresh my recollection.
I can try to do that. Give me one moment. I guess I'll speak generally without getting specific. Would it be generally true that documents would...
We are only on a day 4 out of we don't know how many days. I think this is witness number 6 or 7, and allegedly there's 40 witnesses. So it's a long time till we figure out if he's going to get a new trial.
Excuse me, that CDR records might have a column that indicate what tower was being connected to?
Oh, absolutely.
And based on that tower code, would you agree that anyone, if they know what website to go to, could figure out where that tower is with some effort?
As far as like just putting the latitude and longitude coordinates into a browser to determine its location?
Going the other direction, is it possible to take that, say for example, just hypothetical here, that we know someone connected to a US cellular tower and we have a tower identifier. Is that something someone can take and figure out where that tower is?
It depends on the public records release of the carrier for those locations.
Is it possible?
In this random number generator of a universal...
Everything is possible. This is pure speculation. This is what the defense needs to object to, because He objected to when he was speculating on your behalf. Come on now, wake up.
live in, anything's possible, sir.
Fair enough.
I didn't watch the first trial.
I want to direct your attentions. You discussed doing, in addition to your general report, you did reports of various extractions of devices, right?
I did create reports of specific communications or data points out of some of the devices I did extractions on, yes.
And one of those reports that you did, I believe you titled New Conversation or New Convo Report. Does that sound familiar?
It does.
And would that be in reference to Mr. Mullis' cell phone?
Without referencing the document itself, I'm not recalling specifically which communications those are referencing.
And I can attempt to plug this in here so you can take a look at it, and this will be just for the witness, Your Honor. It's the instruction. Let me know when you can see my screen here.
I see a source extraction data in regards to a phone.
And this is your name up at the top here, is that right?
Yes.
Okay. I'm going to scroll through this briefly. I just want to make sure we're talking about the same document here. What would you need to see to identify what device this was from?
So it mentions the selected device name underneath the device name.
I always said, because I was a kitchen staff, I didn't have to salute people. And they always said, that's not the rules. And I said, oh, I'm sorry. I'll do it next time. Then I started doing with the left hand. I wasn't a good soldier, but I was a popular one.
The manufacturer, and it also, the documents, sorry. So it gives a general idea of the device name there and the brand. Is there another page that gives more specifically the IMEI or some other unique identifier for the device itself?
I'm sorry, I was being asked just a clarification question from counsel. Can you just state that again? I just want to make sure we're on the same page.
Okay, so it shows a device name and it shows a brand. It doesn't show the specific serial number or unique identifier for the device itself that I can see here.
Okay, I'm going to scroll down to the content, see if that helps us get on the same page.
Okay, I'm sorry, I still don't see anything that uniquely identifies the device that this came from.
Okay, let's look at that. But you agree this is a report you generated in your investigation, in your analysis?
It was an extraction report, yes.
Okay, I'm going to scroll down just so we can move on. So what we're seeing now are various messages that have been created as part of your report. Is that fair?
Yes.
Your Honor, I'm sorry, we're just trying to find the document that counsel's referencing. I just need a minute to make sure that we have it.
Certainly, and I can help with that. This is the report that resulted in the State's Exhibit E, proposed Exhibit E. I think it's identified with more specificity in the exhibit list. If you need a minute to find it,
Just give us 1 minute, Your Honor.
Sure, just let us know when you're ready, please.
Yes. We're pulling the data, Your Honor.
Give me just a second. Your Honor, I'm just going to share the file with them just so they don't have to dig through the data. So if we can have just a moment, I want to make sure they're seeing what I'm looking at too. And if you can unshare me so I can look through my files. Thank you. I didn't have the luxury of an extra laptop, unfortunately.
Not if this is going to be every other witness, they're going to annoy the judge. I don't think it's going to work. They did really well yesterday. I like that smiling lawyer. First day, way too long. This lady, way too unsure of herself. And they have to convince the judge, and she's getting really annoyed.
And just for clarity of the record, this was produced to us in discovery, but I agree it was from a large amount of data.
Certainly. Have your screen shared again?
Yes, Your Honor, thank you. Can you see that in front of you again? Or let me know when you can see it.
I can see it now.
All right, so we were looking at this. I'm going to scroll down to page 2, and beginning at the bottom of there, there's messages. So this would be extracted from a device and then is output in.
Yeah, the witness yesterday, yeah, she was doing great. And I think you could get some good answers from this guy if you don't go the long way round. And as someone asked me, they're fighting for this guy's life. They should not have a time bar, and they should, why do I complain so much about, because the judge don't care. It's not going to work that you ask the same question 45 times. The judge have heard everything before. I've told the story a million times. The first year I was a layman. I was told by the head of the court saying, you will only get 4 excuses the rest of the time you're a layman. It's the same 4 they use every time. If you hear a new one, you have to acquit on the spot. And it's true. It's the same 4 excuses every time. It wasn't me. I was forced to do it. I was drunk. It was an accident. You hear it all the time. The judge have heard thousands of cases. Just get to the meat and bones of it.
In this report, is that fair?
Yes.
So I'm going to draw your attention specifically to the bottom of page 5, which I'm going to scroll you there. So in, I think it's conversation or line number 11, do you see that? And I can zoom in.
How do I see it?
So if the first column says phone, what does that mean?
The device type?
Okay, and that next column, it says Todd, and it has a number ending in 1114. Is that the number you testified earlier that was Mr. Mullis's?
I truly apologize. I'm not sure what page number we're on.
Oh, it's like 5.
I just want to show you on this one. Sorry, it's a bit everywhere. It's 511. Yes. Did you locate where we're at, Ms. Thompson, Ms. Sneedson? Okay, thank you, Your Honor. Okay, Mr. Bakke?
I apologize, I don't.
The judge is literally going to write off several of these witnesses that are on the stand for a day. 0 weight, just bring the strong evidence arguments and save the fluffing for me. Yeah, for Brandon, not me. I don't fluff. Yeah, because the guy yesterday, the farmer, even though I loved him, he was a wonderful guy. I want to drink a beer with him. The judge didn't get anything from him. Oh, you saw an accident there. Accidents happened in farms. Okay. Did I sit up there for 90 minutes to say that? Yeah. And I think a lot of... Maybe it's because... I don't know if it's the Innocence Project and they are having untrained lawyers on. And the strategy, I think, will backfire if they don't cut it down. The judge said it multiple times this morning and yesterday to get to the point.
Recall if you answered, so I'm just going to ask it again. That 1114 number, I believe you testified earlier, that was Mr. Mullis's phone number, is that right?
That was the telephone number associated with his account and the device that he had, yes.
And I'm going to scroll up for just a second so we see what that column is called. And at the top of that page, I can scroll there.
Objection, Your Honor, this was not an exhibit that was presented before trial. In the state's exhibit list, they just had an extraction from an unidentified phone extraction. And so this was not disclosed to us which extraction was being used, and also it was not disclosed, this entire report was not disclosed that they were going to use this as an exhibit.
Your Honor, if I may respond.
Go ahead.
This is a report from their expert who they called as a witness from a message from their client, and we filed the actual message as an exhibit, and they objected to authentication and foundation for that exhibit. So that is why I'm having the witness go the long way through the actual report to confirm it was in his full report before we work with the actual exhibit. And I believe in reference to our exhibit list, we confirmed that it was in a report sent to us from Sean Castle's digital extraction on the physical drive produced by applicant during discovery. And if there had been any question as to what report or where in that data it was, we would have been happy to provide that, but no such clarification was requested.
Yes.
May I proceed for a moment to probably clarify this? They gave us a one-page document. May I please?
Go ahead.
They gave us a one-page document. First of all, it doesn't have the same information as what we provided to them. We have no idea who did that actual extraction. And even more concerning is it doesn't have the same information as on the report that we gave them. So I think maybe if we confer for a second, we can maybe figure it out or approach, but we've never seen what they're reading before.
Your Honor, I think I can simply have the witness lay foundation of how reports are generated in Cellebrite from a Cellebrite reader file, and he can explain to counsel how those are generated and printed, or we can substitute it with the full report if they want the entire thing that they produced and gave to us.
Well, okay, counsel, I can give you a couple of minutes to visit if you think that will put an end to the objections. Certainly, it would seem to me that the full report could come in if it's something that this witness generated. Now, I don't want dozens more pages of information that maybe isn't relevant or shouldn't need to be reviewed. If we can whittle it down to one, that would be great. But so again, I don't know what's different on the proposed one page from the full report. I haven't had a chance to compare those. If you think a couple of minutes to confer would be useful, I would suggest that we do that. Why don't we go off the record for a few minutes? Let me know when you're ready. The court will recess.
They forgot to turn the audio back.
They were not able to.
Hey, Maddie B.
The DVR was submitted to my office for further examination.
And Brandon, now he found the gain knob, so I'm just gonna take the enhancer down a few pegs again.
Can I have this one moment? Certainly.
I did a 90-minute stream about a different subject, and we are still almost caught up. I could go read the motion to dismiss and still be on time.
States, first of all, can you hear me? We'd like to read in just the full content of that message that the state just read into the record, or the full message in response to it, so if I may do that.
I can hear the humming, and yes, something will blow our ears out because I don't know what mic it is that they turned the gain up on, because it's not the mic in front of the Mullins team.
Or we'd like to offer again the text message between Todd and Amy Mullis that give the full content of that message, because this is just a snippet of the extraction, not the full extraction. So we would just like to provide the full context of what that message is about or not.
Your Honor, I apologize, but I'm confused. I believe the exhibit I read from is already in evidence. Is counsel intending to read from a different portion that's already in evidence? I'm unclear.
I guess I'm not sure. Are you planning on reading or asking to read from 307?
307.
And I guess for just clarity of the record, briefly, I wasn't intending to testify when I read that message in. It was only because it was abstracted from an exhibit number, and the e-filing stamp was the only reason I read it that way.
Well, and is the reading attached to a question for this witness or not? Sure. I mean, is it being read because there's a question that goes with the reading, or?
I think our argument is that we just want to have the real completeness, that the whole text conversation is considered as a whole instead of just that one isolated text message. And so,
well, okay, and so that's my job in reading the exhibit, which I will do. But, you know, we've put this witness through a lot of hours of testimony, and so I think right now we need to focus on what questions we have for this witness. And so he doesn't need to read that whole exhibit unless there is a question for him.
yes, Your Honor.
Okay.
May I resume?
Yes.
Based on your review of the digital forensic data, were you able to determine that multiple devices were logged into Todd Mullis 76 Google account?
Yes.
And so would this indicate that the Google search history presented at trial could be from multiple devices?
Yes.
Stop whispering.
One moment, Your Honor. Sorry. You can take down the exhibit.
This is so disorganized. The worst part is I actually think that yesterday they raised some questions that could lead to a potential second crime. Today, we have wasted an entire day about some Google searches that they didn't even get the majority of them in, because this is just horrible.
We will, at a later time, renew our motion about the DVR records, extraction records. However, we will not use Mr. Castle's time any longer, so no further questions on behalf of the applicant.
All right, any recross?
Even if it's free.
Additional, thank you.
Okay, thank you, Mr. Kessel. You may step down.
Thank you.
Further evidence on behalf of the applicant?
Yes, Your Honor, we will call Mr. Clare.
Sure. So you can sit comfortably. As a witness, do you swear the testimony you're about to give will be true and correct?
I do.
Go ahead. Take time. Have a seat there. Feel free to adjust the chair and the microphone so you can sit comfortably. Ms. Nichols-Cook, whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name for the court reporter?
It's Gerald Burton Firehelm, Feuerhelm.
And do you also go by Jake?
Yes, prefer that.
Laffy girl is back.
Have you previously been deposed regarding your representation of Todd Mullis?
Yes,
This is his lawyer from the first case. This could get really interesting.
And did you previously sign an affidavit regarding this case?
yes,
And are you an attorney?
I am.
Have you always practiced in Iowa?
And take that cough drop out of your mouth when you're speaking. Jamie, save me. This lady is interviewing a witness with some hard candy in her mouth.
The lawyer?
Yes.
Ooh.
She was putting it up. Even if it's free representation, he's paying too much for it.
Yes,
What area of law do you generally practice in?
almost exclusively criminal defense.
In general, how many years have you been practicing?
46, 45.
Why does she look like she's flirting with him?
She's
What?
probably a very awkward person.
What
Probably
is this
just-
case?
Half.
Has the type of evidence in a criminal case changed in any way between the time you started practicing in criminal law till today?
Yes, lots of technology.
And are you employed by a firm, or do you have your own firm? Where do you work?
I'm a PC, but I'm the solo attorney.
Okay. Have you ever had a legal assistant or support staff person work with you?
Yes,
When you represented Todd Mullis in 2018 and 2019, did you have an assistant?
yes.
What was her name?
Christy Klein, Klyn.
What types of things would Christy do for you?
Everything from answering the phone, scheduling appointments, accumulating and organizing discovery materials. Pretty broad section of what she did.
Over your decades of experience
nice
in the criminal law area, have you represented individuals charged with Class A felonies?
Yes,
Do you know approximately how many of them went to trial?
8 or 10.
In your experience, have you ever consulted with an expert witness for the purposes of representation of a person charged with a Class A felony?
Yes,
Have you consulted with an expert about determining cause of death?
yes,
Have you consulted with an expert regarding digital forensic evidence such as cell phone extractions or cell tower data?
Both.
How often have you used an investigator on a Class A felony?
I would say about half of the cases.
Do you belong to any bar associations?
Iowa State Bar Association, Iowa Association for Justice, and the National Association of Criminal Defense Lawyers.
And are you aware of the American Bar Association?
Yes.
Muffin is such an unusual name, isn't it? Not really. My grandmother was a muffin. My mother was a muffin, and I'm a muffin too. Well, thank you for being a muffin top. Despite the look on my face, you're still talking.
Are you aware that the American Bar Association has issued a defense function standard?
Yes.
Would you agree with me that the prevailing standards for defense attorneys recommend that you continue to reevaluate your need for investigation or experts?
That sounds correct, yes.
I want to turn now to your involvement with Mr. Mullis.
Okay.
How did you come to meet Todd Mullis?
An attorney in Dubuque, I believe, his name is Joey Hoover, who practiced in Polk County, and I knew him from there. I don't know how he knew Mr. Mullis or was connected to him, but as I understand it, Joey had contacted a friend of mine, Roger Owens, who I've...
Yes, this is his attorney in the first case, the one that they are claiming was ineffective counsel.
tried Class A's with on several occasions, and wanted to know if Roger would be interested in getting involved in Mr. Mullis's case. Roger contacted me and said he didn't want to take a case so far out of Des Moines. Thank you. And encouraged me to call Joey about it, and that's how it came to be.
Thank you. At the time that you learned about Mr. Mullis's criminal case, do you recall if he had been arrested or not?
I believe he had.
Did you meet with Mr. Mullis and enter into an engagement letter or anything like that?
I think the first thing I did is I made arrangements with his sister and brother to go out to the farm and have them show me the location of the incident. And I talked to Lynn about whether or not they wanted to retain me. I had not yet met with Todd.
Do you know Lynn's last name?
I'm not sure.
If I told you it was Lynn White, would you?
That was going to be my guess.
Was there another attorney that you worked with on Mr. Mullis's criminal case?
Bob Sabers from Dubuque.
Had you ever worked on a case with Mr. Sabers before?
I'd never met him.
Never even met him?
No.
How did you communicate with Mr. Sabers as co-counsel?
Probably equally phones and emails.
Do you know how often you talked to Todd Mullis while his criminal case was pending?
I really couldn't even guess.
Do you know if Mr. Mullis would call you from jail?
I believe he did.
And was your office set up to accept those types of calls?
Yes.
Do you know if Mr. Mullis sent you letters or wrote notes to you?
Letters mostly.
And I think you mentioned earlier that one reason you'd gotten the referral was because it wasn't that close to where your office was, or it wasn't that close to Des Moines.
Well, Roger Owens didn't want to get involved because this location he didn't want to travel that far to represent somebody, and I was willing to do that.
Do you recall what county Mr. Mullis was being held in?
Independence, I believe. I think that's Buchanan, maybe.
Did you have a regular practice or policy of how you communicated with your clients that were incarcerated?
I prefer meeting them in person. In the jail over in Independence, accommodated that and those phone calls.
Did you speak to Mr. Mullis once a week or once every 2 weeks? Did you have any sort of regular schedule?
I don't think we had really a schedule. I think it would be like if something came up on my end, I would set up a phone call, or if he sent me a letter that had some request or a question in it, I'd respond to that either by a visit or a phone call.
Do you recall ever writing Mr. Mullis letters and sending them to the jail?
I don't think so.
Was it your practice in this case to take internal notes about visits or phone calls with your client?
I'm sure I did, maybe not every time, but yes, I did.
And did you provide your file to subsequent counsel?
Yes, I did. I just gave everything I had to Aaron Hamrock and Tim McCarthy.
I think you have seen some of these letters in your deposition, but just so that we're all on the same page, I'm going to ask that we display Exhibit 233.
It's because it's a bench trial. That's why they're doing it. Oh, well, you're back. Been a hot minute, Tracy Dane.
Are they showing?
No.
Okay.
Doesn't look like it's connected yet, so I'm not sure.
And we can scroll for you when you're ready. I think that one has several pages.
The defendant isn't chained to the floor. He walks around. I don't even think he's shackled.
I don't want to rush you, but do those documents appear to be letters from Todd Mullis to you?
I believe they are, yes.
Do you recall reviewing these letters during your representation of Mr. Mullis before his trial?
Yes.
And am I understanding correctly that your response to any questions Mr. Mullis had would have only been relayed to him in person during a visit or a phone call?
I believe so.
I want to just look at the very bottom of page 1 of 233, the last paragraph. That should be the bottom of page 1. Do you see a paragraph at the bottom of page 1?
Is there any expert? It starts out?
Yes.
Yes.
Do you recall Mr. Mullis asking you about an expert to be used in his defense?
Well, that is posed as a question there.
Okay.
Yes.
And at this time, what was Mr. Mullis's position as to how his wife had died?
He believed it was an accident.
And could this paragraph in this letter be him asking you to get an expert to show it was an accident?
Your Honor, I'm going to object on a couple things. This is one of the exhibits specifically that we had objected to: authenticity, accuracy, identity, or foundation. The letter's undated. It specifically has no identifying information as to the date, time, or otherwise. And also it's hearsay because Mr. Mullis' statements are not statements of a party opponent and therefore are being offered directly to, in violation of Rule 580(2) and 3.
If there are objections to the exhibit, it should probably be admitted before it's specifically referred to. Would you like to respond to the objections?
Sure. Thank you, Your Honor. We've laid some foundation that Mr. Firehelm received letters from Mr. Mullis from jail. He identified these as being letters that he remembers receiving. I could ask Mr. Firehelm the dates of his representation. I do think the record reflects when Mr. Mullis was arrested and when he went to trial. And I guess I don't see how how 802 and 803 would prevent a request from a client to his attorney when that is the claim on post-conviction of ineffective assistance to counsel that we have the burden to show. And I have to elicit evidence about what Mr. Firehome did or didn't do.
I assume these are being offered to show the effect or lack of effect, perhaps, on the reader or recipient. 233 is admitted.
Thank you, Your Honor. Mr. Firehome, did you understand Mr. Mullis to be asking you to hire or retain an expert to determine if you could put on evidence that Ms. Mullis died in an accident?
I don't know if I, excuse me, I don't know if I'd characterize it as a request. It reminds me, that paragraph, of a number of times when, to me, it was like Todd was kind of like shotgunning or spitballing ideas of what about this, what about that, and so forth. So I don't know if I would say that that was a specific request, more of a what about this, or how would this be something to think about or talk about.
Did you contact any experts regarding the manner of Amy Mullis's death?
No.
Did you review any literature or do any investigation into an accidental manner of death?
I reviewed discovery material, which included the manner of death, to allow me to assess whether or not it was an accident or homicide.
And outside
No, it's not. If it's a bad wig, then we're going to send Mo after him, because Mo would never stand for that bad a wig.
of the discovery materials provided to you by the Attorney General's office, did you do anything else?
No other materials or individuals, no.
We can scroll to page 2. In the middle of the page, there's a sentence that refers to looking at the clothing.
Yes.
Is this a request for you or a question for you about examining Amy's clothing that she was wearing when she was injured?
I guess my answer would be similar. I don't know if it's a request or just an idea.
Okay. Did you ever go look at the physical items of clothing that Amy was wearing on November 10th?
I did not. I don't know if Bob did or not.
Okay. I would never ask you to tell me what Bob said.
Okay.
What did you understand that there were 3 items of clothing?
Even if it's a cough drop, spit it out while you're interviewing a witness. It's annoying. You can hear it click on her teeth.
That the state medical examiner had looked at during her autopsy?
I think that's right.
If you go down a little farther on the bottom of page 2, there's a reference about iPads and Amy using the iPad. Do you see that?
Yeah. Yes.
Where, I'm sorry?
It's kind of around the highlight in the very it's not a paragraph, but towards the very end of the letter. Amy used that iPad.
Is this page 5 of the exhibit? Got it. Thank you.
Do you see the portion I'm referencing, Mr. Firehome?
Yes.
Just a minute, okay. I apologize. I am definitely fighting off a cold. Mr. Firehome, was the iPad a piece of evidence at Mr. Mullis's trial, or the data from the iPad?
I think the data was.
And what did you do when your client brought up the issue of the iPad and who used it to investigate that?
It's been like this all day. It's so annoying. If Jamie didn't give me the shock collar every now and again, I would be yelling.
Well, here where he was mentioning multiple people using the iPad. I believe that's something that Bob and I either talked about or traded emails about. I think I saw one where Christie maybe responded to one of Bob's questions about that.
Did you interview any witnesses about who had access to the Mullis family iPad?
Just Mr. Mullis, I think. Maybe Lynn and I may have talked about that too.
Did you take any steps to learn about the password to the iPad?
I don't recall.
Just one moment here. I think I'm done with 233 and we can take it down. Mr. Fireholm, you mentioned you spoke with Todd's sister, Lynn. Do you remember how you communicated with her during your representation of Todd?
I'd say a vast majority was by phone, and there were some emails.
Was she also...
Todd was visibly angry when the trial verdict was read. He said, "This is BS." I don't know. Jamie is the one who watched parts of the first one, so I don't know.
Oh, I remember that, I believe. I think he was like super pissed off. I mean, who wouldn't be if he, didn't do this?
I don't recall many saying, "Oh, you got me." Well,
Yeah.
I did it, so that's fair.
Well, I guess it is what it is. Yeah.
Yeah. I tried. Come on now.
I know.
I don't know, but I still
imagine.
think that he is getting the shaft from this retrial team, whatever it's called. I really don't think they're helping him a lot. Now they're getting into, this lawyer didn't believe that it was an accident. Get to that harder. Make it sure that everyone understands that you chose a different way, and then get into how you forced Todd to believe that.
Yeah.
So in communication with Todd while he was incarcerated?
I think she was, yes.
Do you recall her reaching out to you with requests to meet with Todd?
Lynn was good about reaching out to me after she talked to Todd about either him wanting to talk to me or see me, or maybe even a specific thing he wanted looked into or checked on.
I'm going to represent to you that Todd was arrested at the end of February 2019. Do you know what your first task was after you were retained and began representing Mr. Mullis?
I think my trip to the farm to meet with Mike and Lynn was the first thing.
Okay. And then did you file any motions or take any action in court?
From the get-go, there was a lot of effort put into trying to get Todd out of jail with bond review. I spoke with a bail bond company in Des Moines that I was familiar with and had worked with, talked to Todd, Lynn about resources to acquire a bond.
And would that work have been separate from investigating the charges against Mr. Mullis?
Yes.
Do you recall a time where you requested discovery from the state of Iowa?
I don't know the time, but that probably would have been one of the first things that I did.
When discovery came into your office, what was your process?
I would review it, at least scan it. I don't mean scan it like to copy it, but to look at it. And then talk to Christy, and then Christy was great at organizing, setting up tabs, indexing things, that kind of thing. And then I'd go back and go through it after she had that organization completed.
Are you a paper guy? Do you like hard copies?
She called me the tree killer. Yes, I prefer
I'm
paper.
sure she meant that.
Jamie, are you a paper girl? Do you like hard copies?
Ew.
Or do you prefer a floppy binder?
Ew.
She sounds like she's flirting with him.
all the love.
No, I preferred paper.
So did Christie handle compiling discovery that was tendered to you in an electronic format and making it into paper for you?
Yes.
At the time that you went to trial in September of 2019, did you know if the state had withheld any discovery, or did you identify anything that was missing?
I did not identify anything, and I was assuming the state had produced what they were supposed to.
If we can put up Exhibits 201, I believe you saw these in your deposition. I'm going to show you 201 and 202. Just let me know when you have had a chance to look at 201.
Okay.
Do you recognize that document?
I believe Angela showed this to me in my deposition, and I don't think I do.
For God only knows how many thousands of dollars, because we have somebody else's money to live high on a hog, right? He's not.
To live high on a hook. I love this guy.
For God only knows how many thousands of dollars, because we have somebody else's money to live high on a hog, right? These documents don't deal with this.
Did you learn that the state medical examiner had made comments to DCI that Amy Mullis's manner of death could have been accidental or a fall?
Objection mischaracterizes the evidence.
Counsel, I guess, would you like to rephrase your question, or do you take the position that that's an accurate summary of the statement that was made?
I can withdraw the question and ask another one if you'd like, Your Honor.
Thank you.
Let me just find the spot here. Okay. If we look at the bottom of page 1, there's a paragraph under November 14th, 2018. Do you see that paragraph?
Right now, the witness has page 2 in front of him, so somebody will
Page 1,
change
please.
that.
What date did you say?
It's towards the bottom of the page, November 14th, 2018.
Oh, yeah, I see it.
So, if we go down towards the bottom, there's a sentence that begins, Agent Turbot stated.
Yes, I see it.
If you read that, is that new information to you about what DCI was telling the medical examiner?
I think it is, yes.
And is that type of information that you would have wanted to know for your cross-examination of the state medical examiner?
Sure.
Jamie, can we read this one?
What? No.
Thank you, Brandon, for giving us the insight that he jumped for joy because he could go back to his boy toy. Sometimes Brandon takes it a little further.
Could it have explained?
You always know when it gets boring when Brandon gets sassy.
Where she was getting her information?
Yes, but in other homicide cases that I've been involved in, I've seen this type of exchange between the medical examiners and like a lead investigator. But I just don't think I saw this one.
Okay. We can go to 202.
Stop whispering.
And Exhibit 202 has also been admitted, and it is 2 pages. If you could review that, and I'll just ask that we scroll slowly. Mr. Firehome, do these also appear to be notes about conversations with the state medical examiner?
That's what it looks like.
Okay, and does this, and we can scroll for you if you like, that contain information obtained from the autopsy about injuries?
It appears so.
Does it indicate how long Ms. Mullis would have survived after her injury?
I don't see anything like that on page 2.
I think it might be page 1 at the very bottom.
Yeah, it says, so hard to tell how long she was alive, at least minutes she was alive, not immediately fatal.
Would you have wanted to have these notes available to you at trial to cross-examine the DCI agent, Mr. Turbot, who provided this information or made these notes?
Yes.
Does it also discuss whether Amy Mullis's injuries could have been from a fall, or if so, why not?
There's indications in there about whether it was accident or intentional.
And Mr. Firehome, the first time you saw these documents was during your deposition in 2023?
I believe so.
So he didn't have it at trial. That's interesting.
Okay, we can take that one down. Do you remember the name Deputy Keith Rowley?
I don't recognize that.
Have you learned, I'm sorry, let me start over. Do you recall the state filing a motion in limine pretrial to limit the use of a deputy's name who'd had a prior affair with Amy Mullis?
I'm pretty sure I remember that, yes.
Did you ever learn who that deputy was?
I think we knew the name, yes.
Did you ever receive any documents or information that Deputy Rowley was cleared as a suspect from being involved in Amy Mullis's death?
I don't ever remember seeing any documentation.
Do you remember hearing anything in depositions about clearing Deputy Rowley?
There might have been. The only thing I remember specifically about depositions in that issue was how the case was assigned within the sheriff's office for investigation.
Do you recall seeing any patrol logs for any of the sheriff's deputies from Delaware County on the day that Amy died?
I do not.
Do you recall seeing them during your deposition?
The one of my deposition?
Yes.
I don't recall.
Just a moment, I'm going to pull those up for you. I lost the number, so I apologize for the delay. Okay, should be exhibit 323. Starting payment is at exhibit. It's 209. Okay, 209, sorry. Let me know when you have a chance to look at that, Mr. Fairman. you could scroll through 209 a little bit. It's 12 pages. And when you're ready, let me know what you see.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th?
It's helpful to have as much information as you can, and that was something that we talked about.
Okay, we can take that one down. Did you hire an investigator to help you investigate or to represent Todd Mullis?
Did not hire one.
Do you remember who Jerry Frazier is?
Yes.
Before trial, did you know or investigate where he was on November 10th, 2018?
Yes.
How did you know that?
From discovery.
No, I'm actually thinking about why it's moving so slowly. Why are they not prepared for anything? They keep doing these breaks where they try and figure out their own evidence. And allegedly we need one more witness today. It's 10:30.
Material in his deposition.
Okay, I want to show you Exhibit 212. Should be Frazier cell phone record. Oh, I'm sorry, we don't have 212. We put out 213 and 214. Let me know when you've had a chance to look at 213.
Yeah, that's the cover page of report.
Have you had a chance to review that? Do you recall being asked about cell phone tower records or cell phone records for Jerry Frazier in your 2023 deposition?
I think Angela asked about that.
Do you recall saying that you were surprised to hear testimony about Frazier's location by cell phone tower?
If that's what I said.
Would you like to review your deposition?
Sure, I don't remember that question and answer.
If we could pull up 323 and scroll to the bottom of 42. And if you could review page 42 and 43.
Okay, I do kind of remember this now, yes.
Okay. Do you recall at Mr. Mullis' criminal trial making arguments that Amy could have been killed by Jerry Frazier because of their affair?
I don't remember that specifically, but I could have.
Do you recall your closing argument at the criminal trial?
Not any details, no.
Do you recall whether you argued to the jury that Jerry Frazier was the perpetrator, not Todd?
If that's what the transcript says, I would obviously deny it.
Okay, let me ask a different question. In your mind, leading up to Todd's trial, was Jerry Frazier a suspect in Amy's death?
I would say yes.
And if you look at 42, page 42, line 22, the question asked of you is, okay, but would it be fair to say you were surprised to hear a state witness say they had conducted cell tower analysis and verified Jerry Frazier's location by cell tower analysis? And then at the top of 43, your answer is, I would have to say that would have been a surprise, yeah. Do you recall giving that testimony?
Yes.
Okay. If you had information that Jerry Frazier was not on the Mullis farm November 10th or near it because of cell phone tower data, would you have still argued that he could have killed Amy?
I think you could because of the relationship that they had.
No, this isn't the new evidence.
Did you consider that?
Well, it kind of is the new evidence, but it's still not. They did have an affair, so he is correct in he could potentially still have argued the same way. Just wish they could move faster.
The state had evidence giving Jerry Frazier an alibi for the time that Amy was hurt?
I don't know.
I want to move on from Mr. Frazier. Do you recall deposing Dr. Kelly Cruz from the state medical examiner's office?
Yes.
Do you recall being asked about reviewing that autopsy report in your 2023 deposition?
I think so.
And what actions did you take after you reviewed that autopsy report to investigate it or to verify the opinions within it?
I don't believe I consulted anybody other than talking to Bob about it, that I recall.
Okay. Do you remember testifying in your deposition that it was your personal opinion that you agreed with Dr. Cruz?
I think it did, yes.
And you don't have any forensic pathologist training, is that fair?
No.
Okay. Okay, I want to talk a little bit about the Google searches that were offered at Mr. Mullis's trial. Do you recall that evidence?
Yes.
Do you recall who testified about the Google searches?
I can't remember which state witness did.
If I told you it was law enforcement, would you accept that?
I think I would, yes.
Okay. Did you do any investigation or take any steps to determine if those officers were qualified to testify regarding cell phone data extractions?
They may have mentioned it in their depositions, but I don't recall specifically.
And did you contact your own digital forensic expert to review the data?
No.
Do you remember testifying in your deposition that the Google searches were harmful to Todd?
Yes.
And
I don't know if this is required, but
do you recall if the Google searches were how the state was using those?
He didn't do much.
Doesn't matter. It's still not an effective counsel. Again,
Well, I mean,
he
is
could
that
be sleeping.
Well, no, but I mean, could that, I don't know the law like this, but could that kind of stuff be detrimental? I mean, to not actually
No.
go and consult anybody about this information? How do you,
No.
I mean, is that a fact for real? Because that's stupid.
If the first question from the state is, did Todd disagree with you in your chosen defense of him? And he says, no. Then everything is hunky-dory. The big problem is Todd partook in the defense. So
we say. I want more evidence of like what went down there, because I mean,
yeah, but still, he didn't stand up in court and said, "I want a new lawyer," or he didn't release this lawyer and asked his sister to find him a new one. It's going to be a hell of a hill to come over because he agreed to the defense at the time.
Well, I mean, I understand that. Like, I understand what you're saying, but I also have a little bit of a mindset of like, maybe he thought the lawyer knew best.
Jamie,
He's just a normal guy. He's not us.
No, but it's the same thing. If you get stopped in a 35 going 90 and you said, I didn't know it's a 35, that doesn't matter. The law is the law. It doesn't matter that you don't know you could do something. It's your problem. And sadly, that's how it is. And I know, that's unfair and blah, blah, blah. Yeah, but it's just the reality. He has to prove to the judge that this counselor didn't do what he wanted. But if he didn't fight it, then it's going to be very hard to prove that he wasn't in agreement with this counselor. So, that's the big problem. Is if they like, had a meeting, if they had a meeting where he said, "I'm gonna go after that detective she had an affair with," and he said, "Yeah, sounds reasonable," then how can you claim he did something that's not in agreement with you? So
I want to know if they really discussed any of this stuff with him, because it seems like he was writing them letters like, this is what he thinks, and they were like, okay, cool, we're gonna go.
Yeah, but again, no, it's funny how in America the people held to the highest standard know nothing of the law and need a lawyer. Well, that's the reality, and just because you don't know the law doesn't make that. Because that's why you seek counsel. And if your counsel says, I really think we should swing for someone else did it defense, and you say, I believe so too, then you jagter enig. The dice have been cast.
I mean, I get it, but you put your trust in these people that are supposed to be doing this job for you, and sometimes...
Yeah, but he agreed to what defense he came up with. That's why Sarah Boone lost 6.
I mean, that's what I mean.
But
like,
Sarah
really,
Boone lost
did he?
6 lawyers because she didn't agree with 6 lawyers.
Well, yeah.
This guy agreed with him. And then you can say after, well, I had buyer's remorse. Yes. But you weren't misrepresented at trial if you said yes at the time. And that's why it's going to be detrimental if the first question from the state is, did Todd at any point say, I don't think we should go with that defense because I, in my heart of hearts, believe this was an accident. That's a big problem.
Exactly, Rage.
Your case in chief.
No, but he was represented by a lawyer. He could have gotten another lawyer.
Well, I think they were trying to show that some of the searches were rather specific about harming someone, cheating, spouses, that kind of thing.
Would you characterize that as motive evidence?
Sure.
If you had evidence that Todd did not conduct those searches, would you have used that at trial?
Yes.
Do you recall Todd writing letters and having discussions with you about those Google searches?
It came up in letters, it came up in meetings at the jail, phone calls. Yes.
Did you present any evidence in Todd's defense that he did not make those searches?
I recall during cross-examination of some state's witness, it would have been law enforcement, that there were some obvious searches that, like looking for a dress or something like that, or jewelry, that kind of thing. So I felt that the point was made that not all those searches were done by Todd.
Did you do any work to determine where Todd was on the day of the most offensive searches? The ones that you referenced earlier about unfaithful women?
I don't think so, no.
Do you recall researching or drafting a motion to limit the admission of those Google searches because they were not close in time to Amy's death?
I don't think so.
Did you consider that if searches were being done in May, where Todd would have been at that time?
I didn't try to make that connection, no.
Did you know that your client, Todd Mullis, was a crop farmer?
Yes.
And as a lifelong Iowan, do you know when planting season usually is?
Yep.
When is that?
Depending on the spring, sometimes it's April into May.
But they weren't planting. They were. I don't get that because they weren't out planting. They were in the hog barn, right? Is it related to the searches?
That. That's
But
the whole thing.
I just can't get. Is the planting season relating to the Google searches? So he couldn't have searched it at that time because he would have been in the field, or was he in the field and that's why he couldn't have killed her?
It was from what I remember, it was the whole, like, he was out, during planting season, he was out in the fields during these times. And that
With the Google search?
Yeah, with the Google searches, yeah.
Okay, yeah, because I've been wondering why they keep bringing that up, because he was in a hog barn putting up lights.
Yeah, when it happened, yeah.
Okay, well, that makes more sense now. I'm just pretending I'm listening.
Do you recall discussions with your client about his kids taking a hunter safety course?
Yes.
Did you take any actions to determine what that entailed?
I didn't research. I relied on what Todd told me about it.
If we can show the witness 306, but not published.
It's a high standard, that's for sure.
Mr. Firehelm, can you identify the document? Tell me what the name of it is.
It's titled Today's Hunter, Hunter, and down below it says a guide to hunting responsibly and safely.
Do you know what topics a person needs to learn about to get a hunter safety certificate?
No, I don't. I grew up hunting, but I never took a course.
If you had reviewed this guide before trial and it included information about hypothermia and organs of the body or things like that, could you have used that to explain the Google searches the state presented as motive for Todd to kill Amy?
I think that's reasonable, yeah.
And did you?
So this is actually not as much ineffective counsel as the state withholding evidence, is what I hear. So it's not ineffective counsel, it's counsel infected by the state. Crouching Tiger, Hidden Dane, the Baker Hubsback. Yes.
That's like, a lot of it seems like either he really didn't look into anything extra, and it seems like he wasn't getting certain things too, so it's weird.
Yeah.
You understand that Todd was charged with first-degree murder, which included premeditation or planning, right?
Sure.
If I could show you 223.
Which, that's crazy too, like.
Do you remember discussing with Mr. Sabers about whether you should hire a computer expert?
Yeah.
And I'm showing you an email from May of 2019. If you could tell us when you've reviewed it and identify it for me.
It's going kind of fast, but yeah, it looks like an exchange between myself and Bob and Lynn White.
And did you ever consult with a computer expert or digital forensic expert?
I don't think so, no.
Okay. We can take that one down. Do you remember evidence being tendered to you that included text messages between Ms. Mullis and friends of hers?
Yeah, I think so.
Did you interview any of those friends about those messages?
No interviews, no.
Do you recall deposing some of them?
I think we did, yeah.
Did you seek to issue any subpoenas for cell phone records as part of your defense investigation or preparation?
I don't recall doing that, no.
Do you recall filing a motion in limine before trial asking to prohibit witnesses from testifying to hearsay, especially relevant to the friends of Amy and what Amy had told them about Todd?
I think there was a motion, yes.
Do you recall getting a ruling on that before trial?
Yes.
What was that ruling, if you remember?
Not favorable to our request to limit the evidence.
Do you recall discussing this with Bob Sabers?
Yes.
Oh, I'm sorry, can we show the witness?
The guy on the stand is his attorney from the first trial, and he's a paid attorney who got the case because the first one he reached out to lived too far away.
Exhibit
And,
219, an email with Mr. Sabers?
Searches, I think, were on the iPad, is what it was, and stuff like that. So
Yeah, but connected to his Google account, which
It showed
if Jamie
to me.
borrows my phone, it'll still be my Google account.
Yeah, and they said that like the iPad and her phone and stuff like that was all connected to that.
No, his not because she had her own smartphone, but
Yeah,
yeah,
but they
other
said
devices.
it showed up with his stuff too. Yeah, like his Google account and stuff was linked to it.
Well, the other guy didn't want to have the job because he had too far to travel. I didn't get that far. I've gotten Midwestern women.
Do you recall this email exchange?
Not specifically, but I'm not saying I didn't get it.
If the docket reflects that the judge did not issue a ruling on your motion in limine and reserved it for trial, would you disagree?
Without certainty, no, I wouldn't disagree.
Are you familiar with making hearsay objections during a criminal trial?
Yes,
If you made objections, would those be reflected in the trial transcripts?
sure.
Do you remember a statement by a friend of Ms. Mullis's, Terry Stainer, to the effect of, "Look for me in the timber if I go missing"?
I remember that specifically.
Was that one of the statements that you intended to address with your motion in limine?
That and others like it.
Why that statement and others like it?
Well, it indicated Amy's state of mind and her fear that Todd would harm her.
Did you consider those types of hearsay statements to connote a guilty inference that you would have wanted to keep out of the trial?
Yes.
Do you recall if you and Mr. Sabers discussed what your roles were going to be at the trial?
I don't recall a specific discussion, but I think throughout it, I was the lead counsel and he was taking notes and making suggestions and talking to Todd and that kind of thing.
Do you recall if he passed you notes during the trial?
He did.
I apologize. Excuse me. Do you recall if you read them?
That's difficult to do during a trial. Glance at them, talk about them during a break, that kind of thing.
Did Mr. Sabers handle any witnesses at this trial?
I don't think he did, no.
Do you recall any discussions about who was going to do the opening statement?
I don't think we ever discussed it.
Did you draft an opening statement to review with your client before trial began?
I normally have, I don't know if you call it an outline or notes, but not really a draft, word for word. And I don't recall sharing with Todd about the content of the opening statement before we went to trial.
Do you remember what the premise of your opening statement was?
That Amy was murdered, but not by Todd.
What evidence did you plan to present to show that?
The focus was on Tristan and his testimony about the events of that morning. of who was where.
Did you have any other witnesses or evidence that you planned to present?
I think we called a couple witnesses that had contact with Tristan after, that took him home from the hospital after this had occurred.
Did you have an alternate suspect or another person in mind that you were going to suggest was responsible for Amy's death?
No, I think I talked about that with Todd and Bob, that it wasn't our job to find out who did it. It just cast doubt about Todd being responsible.
Did your client, Mr. Mullis, ever agree to your decision to make that statement in your opening statement?
I never asked him if I could, and he never told me I couldn't. I think going clear back to early on in the case, I made it clear that I did not believe this was an accident and that she was murdered.
And that was based on your own personal opinion or evaluation of the autopsy report?
Autopsy report, police reports, life experiences.
And you don't recall writing any letters to Todd explaining that or asking him if he was in agreement?
I'm sure there weren't any letters. Again, we just generally talked about our theme of the trial.
Do you recall that Tristan testified via closed-circuit television at this criminal trial?
He did.
Do you recall how old he would have been?
14, I think.
And I think you testified a little bit earlier that part of your plan was to focus on Tristan, right?
Yes, significantly.
Did you consider Tristan to be Todd's alibi?
Yes.
Do you recall there being an issue?
Yes, based on the autopsy report.
Yeah, that's what he said.
No, he didn't
And
think
his
he was
life
guilty. He
experience.
thinks someone else did it, but he thinks someone did it to her.
Yeah, he thought it was an unaliving, not an accident.
Yeah.
He just didn't. Yeah.
Between Tristan's pretrial deposition and his trial testimony?
Yes.
Did you do any investigation or take any steps to learn more about the slight change in Tristan's testimony?
It is scary.
If I'm recalling the events accurately, Tristan testified in a deposition, and he gave testimony about the amount of time he would have been absent from.
No, but that's still what he claimed. Based on the autopsy report, he believed that someone else had done it, and that's what he went with at trial.
The location in the hog barn.
Going by her face today, she is more than over this already.
Where he could see Todd. And he gave a time frame that was relatively short. And then afterwards, he met with his attorney, and that attorney came back and said that Tristan said he had made a mistake.
And I guess my question is, did you take any action to look into that?
The action I took, and I believe it's indicated in an email, is that I contacted Todd about this development with Tristan and suggested that we needed more time to do that. But Todd was adamant that he did not want to continue the trial. So other than that, Lynn had provided me with some drone photographs of the hog barn and the shed where Amy was found and that kind of thing. So we used those to show the significant distance between the barns. And if Todd did leave Tristan's eye shot, even for the longer time that Tristan said, I think it was 30 seconds, I don't know what, it would have been impossible to leave the far end of the hog barn, go to the shed, do whatever happened there, and then get back before Tristan missed him.
So that covers everything that you did do
Yes.
to corroborate or to investigate Tristan's testimony?
Yes.
Do you recall
Yeah, so
why
it was like
you
30
called
seconds.
Mr. Mullis to testify at his trial?
That's crazy.
One reason is that so many times when I've talked to jurors after trials, my conclusion was they expect to and want the defendant to testify that they didn't do it, even though you tell them that in voir dire and so forth that they don't have to. And as late as the night before the beginning of the trial, when we met in the Dubuque County Jail, I'm not sure we had decided for sure if Todd was going to testify, but I left that meeting that night with the understanding that we both agreed that he would.
How did you prepare Mr. Mullis to testify?
In those meetings,
Did you ask him questions so he could practice his response?
I don't know if it was questions or answers. We just talked about topics that he would expect to be asked about.
Did you practice any potential cross questions that the prosecutor might ask him?
I don't think so.
Do you remember discussing with Todd that he needed to testify to rebut the Google searches?
I think that is one of the things we talked about, yes.
And was that in part because you didn't have an expert or anybody else to testify about whether Todd made those Google searches?
I don't think that was the reason, no.
Did you cross any other state witnesses about whether Todd Mullis could have done those searches?
There was cross-examination about some of the searches that seemed obvious that Todd would not have done. I can't remember what state witness that would have been.
Did you consider?
Yeah, they barely did anything to prep him either.
Did you consider Todd's credibility to the jury after your opening statement?
Natalie did more prepping with Jen McCabe.
Yeah, exactly.
I take that into account throughout.
Like, this is his life.
Were you concerned that you had told the jury that Todd was wrong when he told investigators Amy died in an accident?
Would you repeat that, please?
Were you concerned about Todd's credibility in front of the jury when you had told the jury in opening that Todd was wrong when he told investigators Amy fell on the corn rake and it was an accident?
I don't think that comment was undermined his credibility. I think Todd honestly thought that when he said that thing. I just said, as we researched or prepared for trial, that was wrong.
Do you remember the 911 call in this case?
Yes.
Do you remember it stipulating to the foundation or the admission of it at trial?
I think so, yes.
Did you ever take the 911 call to the jail so Todd could listen to it before trial?
I think we had a transcript of it, but I don't ever recall playing the audio for him in jail.
If you had been tendered a transcript, would that have been in the discovery?
Yeah, I think so.
I'm just clarifying, you didn't have a transcript made.
No, I don't think so.
Do you remember the prosecutor playing the 911 call during her cross-examination of Todd Mullis?
Yes.
Do you remember two comments towards the end of the call that the prosecutor emphasized?
I do.
Had you ever heard those before?
No.
Were those undisclosed statements made by a criminal defendant?
Objection calls for speculation and a conclusion that's well beyond the actual terms of what he can testify to. The evidence speaks for itself.
Overruled. The witness can answer if he's able.
Could you repeat?
Yeah, I'll rephrase. Are you familiar with rules of evidence that require the disclosure of statements made by a defendant?
Yes.
Before the cross-examination where the prosecutor played that call, have those statements ever been disclosed to you before? Purported statements. So sorry.
Stupid.
Well, the whole 911 call was, we always had that, the whole thing. But the contention that he said certain words, no.
And weren't those phrases highly inflammatory?
Yes.
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
And that was a big deal too. Man, oh man.
No.
Have you made a motion for a mistrial before in a trial?
Yes.
Did you do so in this case?
No.
We can have just one moment. Do you recall the prosecutor telling you off the record that she was going to ask him about these specific statements?
I'm certain that she did not.
Do you recall taking any investigative steps to determine who would have been present at the time of those alleged or purported statements by Todd?
If I'm remembering correctly, the 911 call ended there on the gravel road when law enforcement and, well, first it was law enforcement people showed up. And that's about when supposedly he made these statements that the prosecutor brought up.
If you had had notice of these purported statements, could you have investigated or attempted to discredit that cross-examination question?
Yes, I actually took the 911 call after the trial was over and had it enhanced to try to see if I heard what supposedly was said.
Did you ever learn how the state came to make that argument?
I was told by the prosecutor.
Did you get your own transcript of the call for post-trial motions or anything?
Because of the change in representation, I wasn't involved in the post-trial motions.
When did your representation end? That I should have asked you that first.
Between verdict and sentencing.
In summary, his first attorney got the job because someone else thought it was too far to drive. And he thought after reading the ME report, she probably been stabulated by someone. So let's go with someone else did a defense, even though Todd claimed it was an accident.
So you did not get a transcript of the call before your representation ended, am I right?
I think you're right. I'm not sure we ever had a transcript of it.
Your Honor, can I have just a moment to confirm? May.
Yeah, I'm agreeing. It's a high bar, and as long as he said he didn't object to my testimony or my trial strategy, there's absolutely nothing there. He put on a defense form. He might not like the result, but he got a defense.
Well, his answer of I didn't tell him, but he didn't disagree. Like, I don't know. I don't like that.
Doesn't raise to ineffective counsel.
I know, but the bar shouldn't be.
Who is mouth cocking the microphone?
Nicole, can you find 294 to show Mr. Firehorn? And I'll move on for a moment and come back while you're doing that. I don't think I warned her I was going to do that.
No, and this is the problem in this case. He did have a defense. He had a trial. You can disagree upon the the tactics he used, but as long as he didn't which was it Nick who had a trial where a guy stood up and gave 33 seconds of opening statements and didn't give a closing argument and 2 objections during the trial? That isn't the ineffective counsel. He was there. He did something.
Yeah, but
So,
it should be a lot. I'm just saying, I feel like it should be a lot better than that. And especially
Yeah,
when, she's making argument. I mean, they're bringing out arguments of like, he kept saying, like, that's not what happened. That's not what happened. And I mean, I don't know. I don't know what happened behind the scenes, but like, it's just tough to hear that because it's sad for people. I don't want people sitting in jail if this is really happening to them and you trust these people.
yeah, and again, you get who you get. There's a lot of public defenders out there who just say, "Take a plea, man."
Mm-hmm.
So you get what you pay for, and we see that in a lot of cases.
Yeah, he's been fighting.
Mr. Firehelm, during your 2023.
This is it.
What?
I said, and he's been fighting to get out ever since. I mean, obviously they did his appeal, but it got denied. But like, they've been fighting for this and finally got this, and this is it.
Yeah, and with what they have brought in, the only thing I have heard in these 4 days that I think supports a new trial is that biomechanical engineer, because you can't claim ineffective counsel because he did get a defense. You can disagree about what the defense did for him, but he did get more than we saw in a lot of cases.
Yeah.
We have seen way less defense put on in a lot of cases. We saw the case with the guy who admitted he did it. And yeah, his defense was, please don't be too harsh on him. And then he asked 5 questions. As long as the lawyer showed up, he did cross-examine people. I can't see that it can in any way raise, lower it so much that it'll be ineffective counsel.
Yeah.
It's just trial strategy that he's not agreeing on.
But parts of it was also the evidence and not like evidence like the Google searches and stuff and bringing in the biomechanical engineer. So maybe those will help play a part in it. I don't know.
Well, I got news for you, Jamie. The judge's mind appears to be less open than the Baker HR department.
Maybe. I don't know. I see a lot of questions.
Do you remember being asked about a Greeley EMT? It knows that it's 4 o'clock. Greeley EMS first responders before trial.
No.
So you're doing that. I don't think I warned her I was going to do that. Mr. Firehelm, during your 2023 deposition, do you remember being asked about a Greeley EMT who had filed a report about her response to the 911 call for Amy's injuries?
Yeah, I kind of recall something about that, yes.
Did you do any investigation or take any steps to determine whether the first responders' actions and or CPR could have caused some of Amy Mullis's injuries?
I vaguely recall whether it was the ER doctor at the hospital or possibly during the medical examiners, but I'm not sure of that. I'm sorry.
Did you
She's just eating a head.
talk to any of the Greeley EMS first responders before trial?
No.
Do you recall the Mullis family telling you that Greeley EMS was there and that you could contact them?
I don't recall them telling us that. It was pretty obvious from the reports. They might have.
But did you ever do any follow-up to get the Greeley EMS reports before trial?
Not unless they were in the general discovery.
Did you ever learn that law enforcement was suspicious about how Amy sustained her injuries at the hospital on November 10th?
And he has a nose whistle.
Oh, God.
I honestly can't say when the suspicion began.
Do you recall doing any investigation or interviews with people about that?
Again, and I might be wrong about this, about whether or not that hospital doctor talking to law enforcement, that it may have started then, the actual day.
Did you take any steps to learn about potential conflicts of interest or bias in the investigation?
No.
And were you aware that Amy Mullis had worked at the same hospital where she was taken when she was injured?
Yes, I think we did know that.
And were you aware that some of the witnesses the state called to elicit those hearsay statements worked at that hospital as well?
I think we were aware of that, yes.
Are you ready, Nicole? Okay. What number? 294. If the record could reflect that we're showing the witness exhibit 294. And if you could take a look at the first page and tell me what it is, and then we are happy to scroll through it for you.
It's still dark.
Still loading. It knows that it's 4 o'clock, I think.
Yeah, not showing that it's connected. I'm not sure if you need to try again.
Nope, he was
Can you
higher.
identify the document for me, Mr. Farrell?
And he still doesn't have it yet.
Oh, no. I'm sorry.
Sure.
Sure. Thank you.
And Mr. Baki's computer?
Yes.
All right, let's try that one.
Do you see a transcript of 911 call?
Yes.
What date?
The date of the call,
Yes.
November 10th, 2018.
And does it identify who made the call?
911 call by Todd Mullis.
And if we can start scrolling. Page 15 of the PDF. Could you review that for me, Mr. Fireholm?
Yes.
I want to direct you to line 5. Can you read that for me?
Deputy Luke, here, comma, Todd, let me.
Do you know who Deputy Luke is?
No, not specifically.
If I told you that was Delaware County Sheriff Deputy Luke Thompson, who testified at trial, would you disagree?
No.
Objection, we're reading from evidence. We're reading from a transcript, not an evidence, that the state would object to its admission and consideration of in the first place.
If I could ask 2 more questions, and then I'll move to admit it, Your Honor.
Well, again, if there's an objection to it, we should probably admit it before we get too far in the weeds. I mean, do you think you can get it in through this witness?
That's a no if the judge asks that.
Have just a moment.
Yeah.
Your Honor, it's a certified transcript by a court reporter. I'm not sure what other foundation the state would like to have. Page 17, I think, is where Kimberly Blink does her certificate.
I mean, counsel, any response in that respect?
While we agree that this is a certified transcript of a 911 call that, according to that same certification, is done merely to the best of the court reporter's ability, based upon heavy breathing and inaudibility, this is not a transcript from a court proceeding. It constitutes hearsay. This witness hasn't seen it before, and while it's certified, that may go to its authenticity and to its identification, but it certainly doesn't go to its admissibility outright. So the state objects on lack of foundation, objects also on hearsay, as it falls under the rule and doesn't meet any criteria or exception. And 403(2)B as prejudicial more than probative, given that the Court of Appeals have already addressed this, and a footnote finding that the jury could listen for themselves and believe or disbelieve the arguments of the prosecutor as presented at trial.
Well, I think that certainly Ms. Nichols-Cook, you can ask your questions about the timing and the presence of the deputy in relation to when these statements were made or not made without the use of the transcript. We can address the possibility of this coming in maybe at a later time. I don't think this is the right witness necessarily to do it if it is going to come in, but why don't you proceed? We do need to end at 4:30 today, and I suspect we're not in a position to do that, so go ahead.
Okay. Thank you, Your Honor. Mr. Fireholm, if you could just read through page 15 and 16 for me.
You can just tell me when to scroll.
Page or line?
Page 15 and page 16.
Okay, it's kind of covered up, but I think this is 15. Line 2. Oh, excuse me.
Just scrolling slowly on page.
Sorry, just tell me when you want me to scroll since I'm helping with the technological issues.
Could you let me see the top?
Sure.
Okay, that's good. Line 2 starts out, she's cold.
And right now, you're just reading to yourself, sir.
Oh, I'm sorry. I'm sorry.
It's the same lawyer. Still no answers. Tomorrow I will bring a can of paint, and we will see which is more exciting.
Scroll, please.
Have you been able to review page 15 and 16?
Jamie, that was a joke because it's boring to me.
Yes.
Watching paint dry is more exciting. I got it.
In your review of this
They did
transcript
that
of the
in the
911 call, do you see the two statements the prosecutor asked Mr. Mullis about on his cross-examination?
I do not see those words.
Thank you. We can take it down. Mr. Firehelm, are you aware that the statements represented the source of the Google searches at the criminal trial?
Objection to the categorization of the state's statement and also under Rule 5403. Also vague.
Sustained.
Mr. Firehelm, I'll ask a different question. Are you aware
It's going to be interesting, and then Brandon is going to disappear at 11:30 and come back again at around 4.
that evidence exists that would have rebutted
Sorry, Peter.
the evidence presented at trial, that Todd Mullis alone made the Google searches that the state presented?
I'm not aware of any technical research or document.
Are you aware of digital forensic experts that could examine the iPad and determine information that could potentially contradict the evidence presented at trial?
That's pretty broad. Yeah, I assume an expert could examine it and give an opinion to that. Whether or not it would confirm it or not, I don't know.
If there was evidence that contradicted the state's presentation about the electronic evidence, would you have used that at trial?
I was the OG.
If there was evidence?
Yes.
Yes.
If you were aware of evidence that contradicted the state medical examiner's determination that the manner of death was homicide, would you have presented that at trial?
Yes.
Okay, I think I have one last exhibit to show you, which would be 245. Sorry, 245. Mr. Farnham, do you recognize the document on your screen?
No.
If we can scroll a little bit, and let me know if you do recognize the handwriting or content.
I don't know.
Okay. We can take that one down. Do you recall taking any steps to investigate Amy Mullis's medical condition at the time that she was injured on November 10th?
We were aware that she had had a medical procedure a few days prior.
Did you obtain medical records about Ms. Mullis's procedure or medications that she was on?
If it was in the discovery, yes, I don't recall specifically.
Did you do any investigation into whether Ms. Mullis would have been dizzy on November 10th due to her medications?
No research, no, other than what Todd and Tristan said.
And did you issue any subpoenas to get medical records?
I don't believe so.
Did you have any medical records that you did receive in discovery reviewed by an expert?
No.
Do you recall a letter from Mr. Mullis asking you to, or stating that he wanted to get a 3D demonstration of the injury to show that it was a fall?
No, I don't recall that specifically, no.
If we can pull up 233. And we're going to go to page 11. 233. 233. Is it in front of you, Mr. Farrell?
Yes.
Can you read page 11 and 12? Do you see any drawings or diagrams in this letter?
It's not very clear, but I can tell that there's something there.
I'll look at page,
That one, yes.
we can scroll to page 13.
Your Honor, I'm going to object that this exhibit isn't in evidence. It's hearsay. It hasn't been adequately authenticated. I do believe 213 was admitted into evidence and, oh, I'm sorry, 233 was admitted in full. At this time, I apologize. I withdraw my objection, Your Honor.
Thank you.
Mr. Farham, have you had a chance to look at page 13?
Yes. Excuse me.
And we can scroll to 14 as well. Do you see additional drawings regarding Amy's injuries in this letter from Mr. Mullis?
I do.
Did you take any steps to investigate the information that Mr. Mullis provided to you?
I don't know what the date of this is.
Do you recall taking any steps at any time to investigate
No,
information in this letter?
no forensic experts or witnesses or anything, no.
Okay. Your Honor, I think this is a good place for me to stop. Unfortunately, I think I still have a few more questions for Mr. Fireholm. I don't know if the state would be agreeable to think we have potentially an expert in the morning, and Mr. Firehome might not be able to get back up here until tomorrow afternoon.
And maybe we can have some off-the-record discussion about scheduling briefly. Okay, we'll do that before everybody takes off, but we'll plan on recessing until 9 o'clock in the morning. I have been informed by the clerk of court that they're bringing a crane in tomorrow to move something. So whatever the parking situation was this morning, it's going to be even worse tomorrow, to the extent people want to know that. They may need a couple extra minutes to get here. See you tomorrow at 9. Have a nice night.
Thank you, Your Honor.
Your Honor, would you like to schedule?
Woohoo. What?
I don't even know how to sum up today. Yeah, he had a shitty lawyer the first time around, but he didn't have ineffective counsel. None of this is ineffective counsel. He got a defense, and that's enough. But that's sadly how it is.
I know.
As long as he gave him an opening statement and he cross-examined some people, that passes the bar for ineffective counsel. We saw that in the Jodi Arias lawyer, when they sued for ineffective counsel, said, yeah, met the bar, doesn't need more. The Google searches, I don't know. I got lost after hour 3. Who searched what? I don't know. What time was
They
the
don't even
searches?
know. That's the whole
Maybe.
problem.
Who had a DVR? I don't know. But they played Matlock or Archie Bunker or whatever it was.
Andy Griffith.
Yes. Archie
They
Bunker was.
recorded it at least.
Yeah. Who watched it? I don't know. We are here to find enough new evidence to persuade the judge that this guy should be allowed a new trial. So far, I heard one person give me any reasonable explanation to why, and that was the biomechanical engineer. Asking a lawyer, would you have changed your strategy if you knew this? I don't know. I'm not sure. That's not helping you. Because if he wouldn't have changed his strategy, then the first case was that was good enough. I can't with these. I don't know if it's a freedom project or whatever it is. I can't with the constant whispering, the lack of. Jamie, remember Tuesday when Alessi stood there with his notebook? He had tabs, he had pages, he had little stick-it notes, he had highlighted what he had to bring out. He had everything. He gave page numbers on what was in what affidavit, what was in what sidebar, what was testimony in court. He had all of that. He made that in what was he said, 2 days?
Mm-hmm.
These ladies have had years to prep for this. This is this man's last chance, or he'll gonna go to prison forever. And they can't even get the numbers on the exhibits right. I'm sorry to say this is it's painful to watch. They are no better than his first counsel. I think people are looking at them with rosy eyes because they are helping him, but they are horrible people. in a courtroom. The judge was so fed up with them this morning that she said it yesterday, she said it the day before. Stop talking and get to it. And they just keep asking stupid questions. It's redundant. It's over and over and over and over and over again with the same type of questions. You just open up the possibility for the state to object. And the judge, I think, have been more than fair with them. I don't know. I don't like it.
I mean, I don't know. Yeah, the first lady today was really bad.
Yeah.
She just did, yeah, it was like they threw her in that job just for, hey, give her something to do.
Yeah, some work
But
experience.
well, because if you could heard the lady, every time she was done answering a question, the girl next to her would lean over and tell her what to ask next. And it's like, oh my God, then why are you even doing this? But
Constantly.
I don't know. I mean, in my
No, but
opinion,
we need
I've
we need a
seen some
reason.
things come out that are make things very questionable to me. So I love the
But
biomechanical engineer. I felt like that was good.
but that's
because it
the
made you think.
only hard evidence you have had. If
Well,
you
the Google searches. I mean,
but it doesn't prove anything. Someone Googled something at some point. He can't prove it wasn't him. There's someone testifying.
but they
No,
said it was him. That's the whole thing. So they're trying to disprove the fact that these cops
yeah, but he can't
came in
prove
and said it was
because
him.
he was asked directly, "Can you tell who did the Google search?" He said no. So they can't
No, but
even.
they didn't counteract any of the Google stuff in the trial too. That's the whole thing. You know what I mean? Like they didn't get anybody to say, hey, look, they're all attached to these accounts. It could have been anyone. You know, they didn't do any of that stuff. I mean, you know, so that's like, to me, it's a little eye-opening to be like,
Yeah, but
well,
it's
that's
just not.
something the jury didn't hear.
I don't think that it changes the judge's mind because yes, they didn't ask about the Google searches. Can you tell me he didn't search those Google? No.
Well, I mean, they're trying to get into the whole, I don't know how they're going to get it in. They were trying to get
They
it in
can't
with
get
someone
it
else.
in there.
But the fact that he was not in, he was planting during that time frame.
But that sadly doesn't prove anything because they didn't even have the timeline when the Googling was done. That's the problem because
Well,
she
it's
said
stupid evidence in the
I
beginning.
can't see when these Google searches was made, and he said, well, you can see here, and she said I can't see it. The most important person, it doesn't matter what I think because yeah, I think there's reasonable doubt, but it's the judge, and the judge have signaled to me at least multiple times today that you better get to the point and you better find something. I think she's mad that they can't keep a time schedule. I think she's mad that most of the questions are a waste of time. And you could tell it. She got mad at the state too today. And so far, the only thing, if we are absolutely honest about it, the only thing that could potentially give him a new trial is the biomechanical engineer's testimony. That's the only thing. Those Google searches doesn't mean a thing because you can't prove he didn't do it. If you could 100% say that iPad was in the house, we have 25 witnesses who saw him in his tractor 20 miles away. But they don't. They have no way of proving he didn't search it. Because, yeah, he should be planting. Who says he wasn't in having a bit of breakfast or lunch, or his tractor was broken down?
Well,
you can't prove it.
maybe this is stuff that they are going to bring out. I don't know. We don't know, because I know that when they brought it out in the first trial, it was just, look at all these things he did because he was planning this whole thing and all these Google searches, and look at how, he just wanted to off her from day one. I mean, and they never even like combated that at all. So I don't know. We'll see.
If there was exculpatory evidence that would have completely exonerated Mullis and the lawyer knew about it but chose not to present it, would that be grounds for another trial? Yeah, it'll probably be grounds for disbarment as well.
Well, yeah, that would be a big no-no, right?
But they already had that appeal, and the appeal process went through, and they said, we can't see anything new here either. And that's why I'm sitting here. We had the appeal. I read the ruling from the appeals court, and they did the exact same thing. They just they claimed the same things, but we don't need to waste. Today we wasted all our time. There's nothing new in here. Nothing. Other than potentially someone else who was studying for a hunting license could have been Googling instead of.
Yeah.
And he can't prove it. Yeah. Why
It's
didn't
just
they
like
prep?
circumstantial evidence, putting two and two together. If your kids are taking these courses, then you can put two and two together. But I get it.
Yeah, but then again, how did they treat a horse in the Middle Ages? I'm pretty sure that's not on the hunting license. Maybe, I don't know, American laws are different than Danish, so I'm not sure that it's part of the things you need to Google to figure out where to shoot a deer, how to treat women in the Middle Ages.
Yeah, but we don't even know if that was him either. But they claimed
No. I'm just saying, but you can't disprove it.
Yeah,
and they
you can't
need to
disprove
disprove
any
it.
of
So no, but the problem is he needs to convince the judge that he didn't do it, so there is reason for a new trial. It doesn't matter. All of this BS. He will stay in prison for life if he doesn't find the magic word. This is the only time that you need magic in the courtroom, and where you have to believe that magic exists in the courtroom, because the only new evidence we have been provided that contradicts what was put in the first trial is the biomechanical engineer, because she did what the ME didn't do: examine the wound patterns in the back. The rest is just a reiteration of what had been done before. There were Google searches. She was talking to her bang buddy. Doesn't change shit.
Well, I want to know about
Nothing,
that kid's
absolutely
testimony, too.
nothing today. A lot of absolutely nothing. A lot of asking a lawyer if he thought he had provided ineffective counsel. Yeah, the burden has shifted. He has to prove that there's enough there to give him another bite at the apple.
I know this stuff is just eye-opening to me because it's so sad, because then you're sitting here saying, oh, okay, well, he has this extremely high bar to meet, and I already see flaws. And I get nobody wants to just throw it all out and do it all over again, because you have to have a certain standard, but it's just tough.
No, but the thing is, they have looked at it again, and they still didn't believe it met.
Yeah, but
that it met the level it had to get a new trial, and that's the big problem, because you can feel sorry for this fella, but we have to remember they had two trials. They already had the real trial and then the appeal process, and now he has to have the third judge feel sorry for him. And I'm pretty sure asking about when do you sow seeds in Idaho isn't going to convince her. I'm pretty sure. We don't know. It's alleged that the kids were getting a Honda safety certificate. They haven't provided one. That's why the state objected to it.
I mean, maybe they maybe the son's coming on the stand at some point, I'm sure.
Yeah, but then take all the other absolutely crappy witnesses off the stand. My big problem is we have wasted 2.5 days at least on this trial. Why did we spend 2 hours questioning his former lawyer?
Because it's part of the case.
It's not part of the case. The part of the case is you have to prove something happened that can give him another chance. You don't have to sit there and ask him, do you know when it's sowing season in Iowa? That was one of the questions his former lawyer got.
Yeah.
That's not necessary. Can we at least agree? You can put on all the witnesses, but you can speed up the testimony and the questioning by 50%, and it would still be too much.
I mean, I agree that some questions are goofy, but it's like I kind of like see where they're going with it because it's his last ditch effort, and I mean, this is just my opinion, and they're just like overzealous with all of it to make sure they don't miss a thing, even if it's the dumbest thing over and over again.
But that's just not how it works.
I know.
You have a judge there. The judge is going to read the evidence. She has read the decision from the original trial. She read the decision from the appeals court. She also has a life, and she's also bored to tears. She can't do like I do, agree to join Tom tomorrow, 9 to 9:45. I'll be on with Tom CPU. She can't be looking up. What the hell was I looking at earlier? Oh, a new CPU. She's sitting there bored to tears and have to listen to the sixth witness being asked, when is it sowing season in Iowa? Again, it doesn't prove anything. He could have had the wife's phone in the tractor with him and used that as a hotspot. If his iPad didn't connect.
Well, they put a lot of that out there because you can't use a hotspot if you have no cell phone service. So that's
there's no proof there was no phone service on the field.
Yeah, I think it got so gobbledygooked on some of that.
That's
stuff,
the problem, Jamie. It's gobbledygook. It's BS. It's wasted time. Ask the important questions and stay with them. If you are very, very pro this guy getting a new trial, I don't. I just hate his defense team.
I am because I
but you can't even follow along and remember the facts. The judge is sitting right there listening to the same thing, and she's not pro him. She believes he had two tries, and this is what they're giving. When do you sow? What is an auger? Why have 3 people been asked about what's an auger and what is an auger? Very important. We were asked. 3 people have been asked about it so far. I haven't figured out why they have been asked about an auger. That's a big problem.
Yeah.
No, I don't. I'm not grumpy. I'm just very, very sorry for this guy because he didn't have a good defense in the criminal trial. And these ladies are treating this like it's karaoke night and there's cinnamon snaps on sale.
Mm-hmm.
They are hurting his trial with all of these stupid questions and all of the... This judge have had enough. And they want to bring 40 witnesses and waste her time even more. We are 7 witnesses deep in 4 days. And they couldn't even get through it because none of them know what they are asking. Yeah, but you don't have to ask 3 people what an auger is, and you don't have to ask 5 people when you are sewing. This lady is also in the state. You need to get to the exculpatory evidence. No, and we don't know what the band played. Well, that's what I thought. I thought it was like an Archimedes screw that you use to transport water, just with grain. But then he said yesterday it was like a conveyor belt with rollers in each end. So now I want to know what's an auger. And I'm going to Google it tomorrow when I have to sit here and wait for them to get through. This is like getting Lally to talk about snow. Yeah, it's like a high school play of a trial, and I think the state is horrible as well. They sent Mr. Baldyhead and the guy who's barely out of law school, but they are winning. They get a lot of objections upheld because the other people don't know what and why they're arguing, and then they have to. No, Archimedes screw. He was a Greek, but he was the guy who invented how a screw could transport water. Jamie, just like in
Yes.
the movies, this is all you get, folks, because now it's 11:15, and if Brandon knew military time, he would know it's 23:45. Life goes on. I'm not sure I do after this one. But as always, hopefully see you tomorrow. I will be joining Tom CPU in the morning for half an hour, 45 minutes before stream. Tassalahakko. See you later.
Bye.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
Go
All right, I'm in love.
back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
So there-
Everybody has.